Right. Good morning, everyone. It is Tuesday, July 25th at 11:30 a.m., the appointed time for the start of this hearing. We're going to get started in just a few minutes. I'm noticing that people are still kind of jumping on, so I'm going to wait just about 5 minutes before we actually call the proceeding and get going, because it seems like people are still jumping on. But we will get going in about 5 minutes, okay? Thank you. Okay, we have had a few more people join us, which is wonderful. But I think we should just go ahead and get started. Looks like we have stopped adding, so this is good. Just want to first confirm that my court reporter is on the call and ready to go. Harriet, are you ready?
I'm ready.
Great, Harriet. Thank you so much. All right, then. Thank you all for being here. Let's go ahead and go on the record in Colorado Public Utilities Commission's proceeding number 23R-0085TO. My name is Alenka Hahn, and I am the administrative law judge assigned to this proceeding. It is Tuesday, July 25th, 2023 at 11:30 a.m., the scheduled time for this hearing to begin. This matter comes on for a public comment hearing pursuant to decision number R23-0393-I, dated June 12th, 2023. This public comment hearing is a continuation of the public comment hearings held on April 20th and May 30th, 2023. The April 20th, 2023 hearing was set by Commission Decision number C23-0118, which was issued on February 22nd, 2023. I want to first welcome all of you and thank each and every one of you for being here today to provide public comment. And the Commission has received some written comments since the May 30th, 2023 hearing. I have reviewed those written comments and am prepared to listen to any additional public comments anyone wishes to make today. Before we begin the public comment portion of today's hearing, I would like to make some general comments about this proceeding and how we're going to proceed today. Some of the following information will be repetitive of information I've given out at the April 20th and May 30th, 2023 public comment hearings. I apologize that it will be repetitive. However, I nonetheless ask that you please pay close attention to my statements so that you will be well informed about how today's hearing will proceed. Let me first explain the purpose of today's public comment hearing. The purpose of this public comment hearing is to allow members of the public to provide comments regarding proposed modifications to the Commission's rules governing towing carriers. This proceeding was initiated primarily for the purpose of implementing Colorado House Bill 22-1314, which is now codified in the Colorado Revised Statutes in Title 40, Article 10.1, and Title 42, Article 4. These amendments significantly amended the statutes governing towing carriers and went into effect on August 10th, 2022. The amendments to the towing statutes included new operational standards for towing carriers engaged in non-consensual tows originating from residential private properties, and included a new 24-hour notice requirement, a prohibition against towing carriers acting as authorized agents for private property owners, an obligation for towing carriers to release towed motor vehicles without full payment, and a restriction on towing carriers applying a drop fee for tows that had not yet been completed. On September 26, 2022, a towing carrier, Wyatt's Towing, petitioned the Commission requesting that the Commission promulgate rules addressing House Bill 22-1314. By decision number C22-0705, which was issued on November 9th, 2022, the Commission granted Wyatt's Towing's requests to initiate this rulemaking proceeding. One goal of this rulemaking proceeding is to revise the existing language in the rules to make the rules easier and less confusing for towing carriers to incorporate into their established practices and operations. So to that end, the Commission convened a public stakeholder workshop on December 19th, 2022, which was attended by many members of the towing industry, and at which the proposed amendments to the rules were reviewed and discussed in detail. Stakeholders at the workshop identified several topics they wished to address in this rulemaking proceeding, including temporary towing permits, clarification of appropriate safety and overhead lighting for tow trucks, additional standards for releasing towed vehicles without full payment, and clarification of Commission jurisdiction over towing carriers engaged in vehicle transport. Because the Commission's rules governing towing carriers already address certain aspects of the statutory amendments, such as regulations addressing towing carriers' duties with respect to the care and storage of towed vehicles, minimum and maximum towing rates, and the circumstances by which towing carriers may non-consensually tow a motor vehicle, Commission staff has strived to incorporate proposed changes to the existing rules with minimal revision to the requirements already set forth in the rules. So the resulting proposed rules endeavor to strike a balance between making necessary and appropriate changes to the rules to make them easier to follow, while maintaining the necessary operational and safety standards already required by the Commission's rules, wherever possible. I would also like to state at the outset that based upon the complexity of the proposed changes to the rules, the written comments we recently received, and the proposed changes that were sent out with my last decision, I may be continuing the hearing further to allow further comments and further consideration. All right, a few preliminary matters. Consistent with Commission practice, we are webcasting this hearing, and we have a court reporter taking down everything that's being said. So please speak one at a time, slowly and clearly, to ensure a complete record is made. The chat function normally found in Zoom has been disabled for this hearing, so do not try to make comments in the chat function. You may provide written or oral comments. Written and oral comments will be given the same weight. The Commission does not give greater weight to oral or to written comments. And in fact, the Commission prefers written comments primarily because people tend to be clearer and or more persuasive in writing than when they present comments orally. They can also be more easily reviewed at a later time. If you would prefer to submit written comments, there are 4 primary ways to submit them. 1, through the Commission's electronic filing system that can be found on the Commission's website. 2, through the file a comment or complaint link on the Commission's website. 3, through email, or 4, snail mail, the U.S. Postal Service. The PUC's website address is puc.colorado.gov. The Commission's email address and mailing address can be found on the Commission's website. So to provide a written comment in any of these 4 ways, please also include the proceeding number of this proceeding, which is 23R-0085TO. As noted, the Commission also accepts oral comments. And in addition to providing oral comments today, you can leave the Commission a voicemail message with your oral comments at any time by calling 303-869-3490. Again, that's 303-869-3490. And I believe that phone number is also on the Commission's website. You may look it up. If you leave a voicemail message with your comments, please be sure to include this proceeding number, which is, again, 23R-0085TO. Your voicemail comments will then be transcribed and placed in the record of this proceeding, and I will review them. Okay. If you are here today to provide public comments, I'll now go over the steps for providing public comment during this hearing. First, if you haven't already done so, please change your Zoom name to your first and last name. And if you are with an organization, I would ask that you also indicate the entity who you are representing at this hearing. This is important for a clear record and will let me know on whom I should call to speak. I ask that you use the raise hand Zoom feature to signal when you wish to speak. To do so, you click the reactions button and raise your hand. Leave your hand raised until you've been called on. If you no longer wish to speak, please lower your hand. If you do not know how to use the raise hand feature, you may instead turn on your video to signal you wish to speak. So then I ask that you please remain on mute with your camera turned off until your name is called. And then please mute your microphone again after you are done speaking and providing comment. While you are speaking, please speak slowly and enunciate as well as possible. Only one person may speak at a time. Do not speak over one another. We want to ensure that the court reporter can hear and understand your comments so that an accurate record of the proceeding is captured. And if somebody has covered all of the points you intended to include in your comments, please feel free during your comments to merely state that you agree with the points made by that person. If there's anyone participating by phone, I don't see anyone, but I will state this as well in case somebody needs to. Oh, actually, I believe there is one. I see one iPhone. You will need to dial *9 to use the raise hand Zoom feature. Please listen very carefully for your area code if you've provided that as the identifier. And when you hear the last digits of your phone number called, you will need to dial *6 to unmute yourself. When I call your name or phone number, please unmute and turn on your video if you have that capability. Begin your comments by stating your first and last name. We need you to do that so that we have a complete record of who has spoken. When you are speaking again, please remember we have a court reporter making a transcript of everything that is said. So it is important that you speak slowly and clearly, and please do not attempt to speak over others or interrupt those who are already giving comments. If you do, the call reporter may interrupt you and ask you to repeat yourself or to slow down. And to anybody who is here today who does not wish to speak and is only here to observe, we are live streaming this hearing on the PUC's website. The link is in the bottom right corner. It's puc.colorado.gov/webcasts. We are in hearing room B. If you are not making comments, please use the webcast to observe the hearing and leave the Zoom meeting. And please know that you are free to join back at any time if you decide you wish to make comments. Okay, turning to the comment portion of the hearing. Okay. To facilitate today's discussion, I'm going to be asking for comments pertaining to some specific proposed rules. I'm going to try and do so in turn to streamline the comments and to keep our discussion as organized and clear as possible. So if you have a comment you wish to make about a specific proposed rule, please wait to make that comment until you either hear me call out that rule number. If you don't hear me call it out, please know that I will be providing time at the end of the public comment portion for you to make any comments you wish to make. And because this is our third hearing and we've already discussed a number of the proposed rules in detail, I won't be calling out for comments with respect to each and every rule as I have in prior public comment hearings. As I indicated, though, I will be allowing time at the end of this public comment hearing for anyone to address any other issues pertaining to the rules that we may not have otherwise covered, and you may then raise any issues that have not already been discussed. All right. Now that I've laid out the procedures and the purpose of this hearing, let's turn to the public comment portion of the hearing. And as before, I'm going to try with the specific comments that I'm looking for proceed in the order in which they appear in the proposed rules. So given that, I'm going to commence with Rule 6501, which is the definitions portion. I would like to first solicit any comments that may be out there pertaining to the addition of the phrase authorized operator to the definition of authorized operator of a motor vehicle. This definition was expanded a bit from an earlier version to incorporate the term authorized operator into the definition. So that then expands that a bit. And my incredible legal assistant, I'm not sure if it's Casey or Stephanie, read my mind and pulled up the proposed version of 6501. So you can see subsection E there, as in Eric, has a definition of authorized operator of a motor vehicle or authorized operator. Okay, does anyone have any comments about this proposed rule change? Please go ahead and raise your hand. Hang on. I think I need to change my, hang on. Let's see.
It's because I'm sharing the screen. They'll appear on the side. If anyone was raising a hand, they'll pop up on the side. But I'm also looking at the participants list and no one has a hand raised.
Thank you so much, Casey. Yeah, I changed my screen format so that I've got the participants listed on the side so that if anybody does have a comment or raises a hand, I will see it in there. And I have my incredibly capable legal assistant, Casey, helping me out. So she will keep an eye out as well. Okay, but I don't see anybody having any comments with respect to the definition of authorized operator in Rule 6501E as in Eric. So given that, let's move on to the next one, which was the addition of the sub-definitions to private property impound. We had already discussed the addition of definitions for commercial PPI and residential PPI at the last public comment hearing. And we had quite a robust conversation about the scope of that definition. But following the last public comment hearing, Commission advisory staff came up with some even further revised proposed language, which was included in my decision number R23-0393-I, which I issued on June 12th, 2023, and which is now up on the screen. Wyatt's Towing submitted some written comments, which we did receive and reviewed about the proposed sub-definitions, but as I read Wyatt's comments, it looks as if they were referring to the prior version and not this most recent version that I included in that decision. But if anyone has any comments about this proposed version, I would greatly appreciate it. And just for the record, for private property impound we're proposing adding 2 sub-definitions, subsection Roman numeral 1, commercial PPI, which would now be defined as a non-consensual tow from commercial private property that is not in a common parking area, and Roman numeral 2, a residential PPI, which is a non-consensual tow from residential private property, including from a common parking area. And we were hoping that with this change that perhaps it was a little simpler and easier to understand. I see Mr. Forbes has turned on his camera. Do you want to go ahead and speak, Mr. Forbes?
Thank you, Your Honor. Trevor Forbes, representing Wyatt's Towing. I guess more it's a question that maybe for staff, especially on the commercial portion. What is the purpose of even mentioning common parking? I mean, our perspective was that if it's on commercial property that's zoned commercial, it's always a commercial PPI. And if it's on residential and zoned residential, it's always a residential PPI. I guess when I look at the commercial portion, is if it was on commercial property and was in a common parking area, then what would that be? It just seems it's extra confusion, I guess, but maybe there's something I'm missing on why they need to carve that out.
Are you saying, do you think commercial PPI should just say is a non-consensual tow from a commercial private property, period? And just take out the phrase about that is not a common parking area? You think that phrase added to commercial PPI makes it more confusing?
Correct. And again, that may be something I'm missing, so maybe staff might have some comments, but
okay.
But basically, what is as a practical matter, when you're on a kind of property, what is a common parking area? Is a common parking area creates lots of gray areas and confusion. It really doesn't benefit the carrier in any way. I don't think benefit staff trying to figure that out. So I would just argue that, like, if it's commercial property, it's commercial PPI and those rules apply. If it's residential and those rules apply. And defining a common parking area in reference to these definitions might create more confusion. But again, I may be missing something.
Well, I'm going to ask Mr. Riley to help me address your question. My understanding is common parking area is taken from the statute, so I'm not sure we can completely work around it. Mr. Riley, do you have any response to Mr. Forbes' question?
Thank you, Your Honor. Nathan Riley, Chief of Transportation at the PUC, speaking on behalf of transportation staff. So I think obviously this what the adjustments we're making here to the definition of a private property impound is based on the 4010.14059 applicability provision of the new statutes. And again, the way they were phrased just does make reference to this common parking area overlay to whether or not the statutes apply and when they don't. I think the reason we kept it in, because I see your point, Mr. Forbes, about the potential to maybe just scrub out the part of the commercial PPI sub-definition to eliminate the term common parking area altogether. I think the reason we left it in, again, is because, as Judge Hahn indicated, it is part of the statute under that 4059 provision. But also, there are these almost hybrid-like properties that we've seen in some of our cases where they could potentially be commercial property but have some type of tie-in to residential parking and may, per the other definition of a common parking area, actually meet that definition of a common parking area. And so I think we just wanted to clarify through the sub-definition of commercial PPI that even though something may be on commercial property, if there is some type of a residential parking tie-in in one of these hybrid-like properties, and that parking situation does meet the standard of a common parking area per the other statutory definition, those would not be excluded. Like it would still be, I guess, expected that these new statutes would apply because there is that residential parking tie-in, at least to the extent that it would meet the definition of what a common parking area is, if that answers your question.
It does. Thank you. That's what I was missing. So in this particular case, I see what you're saying. There's few of them, but these kind of mixed use things actually are becoming more prominent. That in this, as the carrier, I'm looking at and saying, okay, if it's a common parking area, then by definition, the residential PPI rules apply. So it defaults to the residential PPI, which are more restrictive rules in that situation. So I'm now good with this. This makes sense to me, and I think it makes sense.
Great. Thank you so much for explaining that, Mr. Riley. And I'm sure Mr. Forbes appreciates it because it's completely clarified it. Does anybody else have a question or comment about these further revised and clarified subdefinitions for commercial PPI and residential PPI? No one? Okay. Moving on then. Okay. Casey, if you don't mind scrolling up just a little bit to highlight Rule 6504, that's probably enough. This was just a small change. There was a further revision to Rule 6504. 6504 requires criminal history checks on applicants and permits the denial of an application based on a, quote, good cause determination. There was some discussion earlier about whether that it was unclear to whom the rule applies. And so this further revision tried to clarify that it applies to, quote, principles, end quote, and refers back to the definition for principles in Rule 6001, 3 small I. So 6001, subsection III. That is Rule 6001 is the general definitions of the transportation rules. And I don't think we have this to pull up, so I'm just going to read it, and hopefully if anybody needs to, they can pull it up on their own computers. But let me read what the definition is for principle. Rule 6001, subsection 3 small i's, III, states that a principal means a person who, Roman numeral 1, participates directly or indirectly in a firm, partnership, corporation, company, association, joint stock association, or other legal entity taking an action as an entity. Roman numeral 2 is authorized to act on behalf of an entity. Roman numeral 3 participates in the election, appointment, or hiring of persons that are authorized to act on behalf of an entity. And Roman numeral 4, through his or her conduct or activity, directly or indirectly controls an entity subject to the commission's jurisdiction, irrespective of his or her formal title or financial interest in the entity. Examples of principals include the owner of a sole proprietorship, a member or manager of a limited liability company, a partner in a partnership, and an officer, director, or shareholder of a corporation. So this proposed revision to Rule 6504, subsection A, would incorporate this definition that I just read, taken from 6001 III, the definition of a principal. Does anybody have any comments or questions about this proposed change? We were hoping in doing so that maybe that would make the definition and scope as clear as possible. Comments? No one? Okay. Well then, I guess that means everybody's okay with that particular rendition. Okay. And we also had a discussion about Rule 6506, equipment, warning lights, and overhead lighting. I don't think we need to discuss that anymore, although if anybody has a comment, I will come back to it. So moving on to the next section that I incorporated into decision R23-0393, which is Rule 6512. Perfect. Thanks, Casey. This pertains to the release of a motor vehicle to a party, to the vehicle owner or an authorized operator. In In the last round, we proposed amending and revising further subsection L, as in Larry, with the addition of a provision specifying conditions in which a non-consensually towed vehicle must be immediately retrieved, right? You pay the 15% payment of the fee, you have to have certain signs, and we clarified that it applies to residential PPIs, which we talked about earlier as being defined. The new proposed change permits vehicle owners or authorized operators to pay the 15% of the fees up to $60 to retrieve the vehicle. And so that is a bit of an expansion, and I wanted to see if there's any comments specifically about including authorized operators as individuals who may pick up and retrieve a non-consensually towed vehicle or a towed vehicle. Does anyone have a comment about that? Because that is a fairly significant change. Mr. Forbes, go ahead.
Thank you, Your Honor. And just because this has been a topic of a lot of discussion, I just want to say that we agree with this. We think it's fine. Generally speaking, the recommendations from the AG's office are very welcomed. And we would have liked to have some clarity about a year ago when we asked multiple government agencies about this, but late is better than never. And so we think it provides some clarity, and operators can comply with this and shouldn't be an issue.
Great. Okay. Thank you, Mr. Forbes. Does anyone else have a comment about this proposed change? It doesn't sound like anyone has any objection to it, and I guess it sounds like it's acceptable to Wyatt's, and I'm going to extrapolate from that perhaps it's even acceptable to other towing carriers, as no one has piped up to object. So that's great. The other addition, and this is something new since our last public comment hearing, it was Roman numeral 3, which is kind of on the next page on page 6. Yeah, right there. Thanks, Casey. That's the addition of a provision that would impose a 60-day deadline within which to pay the remaining balance of any towing fee. We had heard some questions and comments from towing carriers that perhaps if it was too open-ended and didn't end, with a deadline date certain by which the remaining balance needed to be paid, then it would be very difficult to go out and collect it, because collection agencies need to know that the bill was due in order to do so. So this was incorporated to address those concerns, and a suggestion was made that bills be paid, that they not be due with less than 30 days, but should be paid within 60. So I'm asking for comments about that. Mr. Connolly, you have your hand up. Please go ahead.
Yes, John Connolly, Connolly's Towing. Yes, we think that's awesome. That helps to clarify many issues.
Wonderful. Thank you. Do you have, okay. And you have any other additional proposals? That all looks good to you?
No, I mean, that's great. At least it puts some kind of boundary there of what we're supposed to do after the fact. So that's great.
Okay. Wonderful. Does anyone else have any further comments about, where are we? 6512 L Roman numeral 3. Mr. Forbes, please go ahead.
Just agree with Mr. Connolly. This is super helpful. As a practical matter, I don't, and I'm just speaking for us, not all carriers. If it was 90 days, I don't think it harms the carrier at all as a practical matter. I mean, I don't think you can anything to collections or something like that for 90 days anyway. So if you give an extra 30 days, it gives consumers, 30 days more. Yeah, fine.
Okay, that it's 90 days sounds fine. So you would say the remaining balance owed to the towing carrier shall be due no less than 30 days, but no more than 90 days after the motor vehicle has been released. And you're fine with that? Okay.
Correct.
Okay. Thank you, Mr. Forbes. I appreciate that. Okay, anyone else? My pen just died. Mr. Connolly, you still have your hand up. Did you want to make further comments or? Did you forget? Did you not put it down afterwards?
Sorry, I forgot to put it down.
No worries. Okay. Anyone else have any comments about 6512 L Roman numeral 3? No? Okay. All right, great. Moving along. The last issue I had on my list of issues that I would like to discuss today concerns a proposal from the Attorney General's Office, the Consumer Protection Division, Consumer Protection Section, excuse me, expressing its concerns about what it termed compulsory loans. I believe we have a representative from the Consumer Protection Section joining us, and I would like invite that individual to please, if you could, state on the record what those concerns are so that all those participating today have an understanding of where the AG's office is coming from. Go ahead. I see Martha Fulford. Am I saying that right? Fulford?
Thank you. Yes, Dr. Han, thank you very much.
Thank you. Go ahead.
And as you said, my name is Martha Fulford. I'm an assistant deputy in the Consumer Protection Section of the Office of the Attorney General and also administrator of the Consumer Credit Code. We submitted a written comment and would encourage you to primarily rely on that, but just briefly to reiterate the concerns that we had about compulsory loans, we would we suggest that the rules clarify that these loans may not be required. We think there are substantial consumer harms that may arise from these compulsory loans, including that the finance charge is inconsistent with the plain language of the statute and permits charging more than is owed. And it would also be inconsistent with the intent of the bill as well. Other consumer harms include late fees, negative credit reporting, ACH or debit card access that may come through a loan that changes the leverage, and this account access does not permit consumers to manage other debts, and the loans may also come with arbitration clauses where consumers might sign rights to bring actions in court.
When you say may not be required, are you saying that you think they should be prohibited altogether? Or I'm not sure what you mean when you say may not be required.
Sorry. So in our written comment, we proposed the following language.
Mm-hmm.
A towing carrier may not require a consumer to enter into a loan or lending agreement as a condition of releasing a vehicle under the statute.
Okay. So I guess let me ask you a few questions with Fulford, because I want to make sure I completely understand the AG's office position. First of all, one of the questions that popped up as I first read your comments was that I wasn't clear exactly how you would define compulsory loans. And I think if we're going to include something about that in the rules, we need to be able to define it and provide a scope. So do you have a definition that you could offer or perhaps provide in a written comment later?
Certainly, Your Honor. I think we'd be happy to provide a definition. I think the intent of our proposed language was to clarify that it would be a loan or lending agreement that was offered as a condition of releasing the vehicle under CRS 40-10.1-4055C Roman 1.
Let me ask you this. So if somebody comes back to get their car and they just need a payment plan but not a loan to do so, are these loans, compulsory loans, being required in those situations? I guess I'm not clear in what situations are these being required. When you say they're required, are they being required in every instance where it's not fully paid, or just in those where somebody says they don't have the funds to pay? If you know do you see what I'm saying? I mean, there's a difference to me between somebody who says, I don't have the cash on hand, I'm not gonna be able to do this, I need a loan to be able to pay this back. And somebody who says, well, I can pay it off in installments over time, but I don't need a loan to do so. So in what situations is a compulsory loan being required?
Certainly, Your Honor. And I think that we tried to address this in our comment in the second section of the comment, where we discussed the possibility that Colorado law provides for statutory interest. And it's typical for, for example, a collection agency to enter into a payment plan for a consumer who can't afford to pay the.
Oh, you've cut out a bit, so I don't know if it's me or you, but can you repeat what you just said, because you froze for a minute?
My apologies. So it's typical
Don't worry.
in a debt collection situation where a third-party collection agency might offer a payment plan for a consumer who can't afford to pay a full lump sum of their debt, be it a towing fee or a medical debt or a loan, and to offer that payment plan. Colorado law provides for statutory interest where an agreement doesn't already provide for interest, but those would be at the consumer's option and not required as a condition of receiving the loan, and it would be at the statutory interest rate.
Okay, so you're not proposing that we eliminate loan programs altogether. Those should still be out there, but just perhaps work into the rule that the statutory interest rate can't exceed that 8%. Is that what you're proposing?
Right, and I think conceptually we would distinguish, Your Honor, between a payment plan and a loan.
Okay. Okay. I guess my one last question is, so in your mind, the 8% interest is kind of the middle ground, allowing people the flexibility to take out a loan if they want, but capping the interest so that it's not predatory. Is that fair?
Well, I won't speak. I think Colorado law provides for what the statutory interest rate is, and so that's where there's an agreement that doesn't provide for interest rate, and a loan could include other kinds of provisions that we believe the consumer shouldn't be required to adhere to, such as I mentioned, an arbitration agreement or access to their accounts through ACH or debit. Or other things like that. We think that the consumer should have the option to pay over time, and that is typical through a third-party collection situation. I think our comment suggested that the repayment starting at a reasonable date, certain 60 or 90 days out, which was, I think, the topic of your prior discussion. So the consumer would have time to either gather the full amount or decide to enter into a payment plan, but it wouldn't be as a condition of getting their vehicle released. They should receive the benefit of the statutory reduced release provision. And it's not a barrier that would be contemplated by the statute to have to enter into a loan or a payment plan.
And just, Mr. Newman, I see your hand up, but I have a few more questions for Ms. Fulford, so I will not forget you. Just give me a moment. Ms. Fulford, I guess my next question then is, if we're going to address this in the rules, how often is this happening? Do you have a sense of how many people are being required to do a compulsory loan, and what are the interest rates that are being asked of them and imposed upon them by these compulsory loans?
Your Honor, I'm somewhat limited in what I can share. I will note that our written comment said that we are aware of at least one towing carrier, but other than that, I think I should leave it there, and perhaps others might be able to share information of what they're seeing in the marketplace.
Okay, that's fine. I just feel like if we're going to work this in there, how big a problem is it that we're trying to address? And if we're addressing it for just one situation over several years, that didn't. So I just wanted to try and get a sense of how prevalent is this practice. Do you have anything else you wanted to add, Ms. Fulford? I didn't have any other specific questions for you at this point.
No, thank you, Your Honor, and we're happy to provide additional written comments if that's helpful.
It would be. Thank you so much. I really appreciate it, Ms. Fulford. Thank you. Thank you for joining us, and thank you for explaining that. Mr. Newman, you've had your hand up for a bit. Please go ahead.
Thank you, Judge Hong. Good to be back and see everyone.
Nice
I was just going to build on Ms. Fulford's.
Could you state your name and your affiliation first before you get rolling?
Of course, yeah. Zach Newman, and I'm with the Community Economic Defense Project, CEDP.
Okay, thank you. Go ahead.
Yeah, I was just going to build on Miss Fulford's comment. I mean, our read of the statute here is very clear. The way the law is written is that when a consumer wishes to recover their vehicle under the provisions laid out in 1314, they have to provide the PUC form, and they have to pay 15% of the balance, or $60, whichever is less, and then they recover their vehicle. Any requirement to sign a payment plan agreement, any requirement to apply for and be approved for a loan, a practice that at least one operator was operating under for a period of time, to us is not consistent with HB 1314. And we can submit that as a written comment and direct you towards statute. But I think any additional conditions placed upon vehicle release beyond the PUC form and beyond that payment are inconsistent with the plain language of 1314.
Okay. Thank you, Mr. Newman. Appreciate that. Mr. Forbes, you turned your video on. Please go ahead.
Thank you, Your Honor. I guess I too would say we've been very confused. I think what we can be clear about is this is written in a confusing way. It's hard to differentiate between, well, do they owe money and is that a loan or not? That being said, I think we do, and maybe I'm misstating the AG's position, that it is frankly better for carriers, and we've determined this, to just be more simple, right? And so if the rule just basically stated, hey, like there's no interest, right? That, hey, they need to pay and they have, in this case, 90 days. And then after that, if they don't pay, then hey, it can be sent to collections, but no interest can be charged. Like that probably makes it simpler for everybody. So just to be clear, the industry is not making a bunch of money off interest, nor do we plan to become a loan business. We prefer not to. And it does, this situation does happen a lot. I think at our business alone, we've lost over maybe probably around $150,000 since this went into effect in revenue. But like those people aren't coming back and paying one way or another. So regardless of whether there was a high interest loan or a low interest loan or no interest, they have no intention of paying. And an interest rate is not going to change that, right? And so, mostly we are in concurrence, I think, and correct me if I'm misstating the AG's position, Mr. Newman's position. They're just saying, hey, no interest is allowed, or maybe, hey, you can charge interest after the 90-day period, the statutory interest that was mentioned. That might be fine too, because maybe just it gives a little bit of an incentive for someone to pay. But I don't think the industry believes that we're going to create a new business model out of predatory lending or anything like that. So we don't have a strong opinion on being able to charge interest or not.
Okay. Thank you, Mr. Forbes. That helps tremendously, because I was under the impression that the industry was more pro being able to collect that interest. So knowing that you're not definitely changes the complexion of it. Ms. Fulford, I'm going to ask you to directly respond to Mr. Forbes's comments. If you wouldn't mind, it would help me tremendously.
Certainly. I mean, I think we think that I think that 90 days and no interest would probably be, without having consulted with our office, I don't think that we can take a position, but
Sure.
We do think that I think that the statute contemplates that there would not be barriers to a consumer taking advantage of the reduced release provision, and interest could just be one of those barriers.
Okay. But that sounds like a payment plan that doesn't impose interest, but maybe interest might kick in after 90 days at a lower, the 8% rate. Doesn't sound like something the AG's office, it's not in, how should I put it? It's not in conflict with what the AG proposed in its written comments, in my mind. Does that seem fair?
I think that's fair, Your Honor.
Okay, that's great. All right, does anyone else have any comments about the compulsory loan provisions and essentially a prohibition of it, or as proposed by the AG's office? No, nobody else? Okay. I'm going to then ask Mr. Riley to weigh in, and he's wonderful at providing additional context and explanation. So, Mr. Riley, if you don't mind addressing the issue, I'd appreciate it.
Thank you, Your Honor. Yeah, I certainly have heard everything that everybody has said on this issue. I think we're all still just trying to sort out exactly how best to practically apply this new statutory measure. I know that Mr. Forbes had commented about wanting to get feedback from various government agencies on how this was supposed to work. I think, just based on the back and forth we've observed so far, it has been a bit confusing to determine to what extent the commission should oversee which methods a towing carrier may elect to use to try to pursue the debt after a vehicle has been released through this method. I think it's been difficult for us to find that appropriate balance, how kind of far into the other side the commission should or could travel to oversee how the towing carriers are attempting to collect the debt after the fact. I think the statute does, to a certain extent, contemplate types of methods that the towing carriers could use to pursue that debt after the vehicle has been released, including initiating a court action or using a collection agency. I don't know that the statute is worded in a way that restricts it to only those two possibilities, which I think may be why we've seen towing carriers attempt to kind of get creative and come up with other alternative methods to use, to best support their business interests. I do worry about putting some type of a restrictive measure in place, because again, the statute does clearly point out that two potential options for the towing carriers to use to pursue the debt is court action and collection agency. I don't know that the commission has jurisdiction to essentially deny a towing carrier electing to use one of those two methods, restrict any, for example, interest charges that may be associated with a court's decision, for example, or a collection agency's standard practice of applying some type of an interest charge when they become involved in the collection of a debt. I don't know that the commission's jurisdiction extends to prohibit that in some way. That's what worries me, is that, and I think that's why we've been to date so reluctant to wade into this area, because first off, it's not our expertise. We're not very well versed in all the different statutes or regulations associated with any kind of a debt collection that is exterior to the commission. And so I think that's why we've been hesitant to give any kind of guidance in regards to what may be appropriate or what may not be appropriate. But again, I think based on the feedback we've heard and we've seen in the written comments, does indicate that it doesn't seem like most people feel comfortable with using some kind of a loan method to pursue the debt. But at the same time, I'm trying to figure out a appropriate way to potentially put such a restriction in commission rule, while at the same time not crossing any other boundaries with any other statutes or regulations that we may not be familiar with, which is why we definitely appreciate the AG coming and providing commentary on this, because we definitely don't want to put something in rule that is going to violate some other boundary somewhere. So definitely appreciate their comments, but this has been a very difficult new provision to navigate. And I think we've given the towing carriers as best guidance as we've been able to provide. But at the same time, I think we have seen enough of an issue with some of the methods that they have elected to pursue that, I mean, maybe it is appropriate to put something in rule, perhaps prohibiting, for example, I believe the AG's comment said something about potentially just prohibiting using a loan as a metric or some kind of a method. Maybe if it was voluntary, that might change the view on all this. But yeah, again, I worry about potentially putting some kind of a prohibition in the rule like that might conflict with something else that we're not aware of. And I just, that would be unfortunate if that was the situation.
Certainly.
So I guess that would be overall my comments on this. Again, I do think that the statute does contemplate certain actions, but not others. And so, you know, if we prohibit one potential method, like, you know, using a loan to support some type of a repayment program, I mean, is there anything else we should prohibit? Like, this is why it's been difficult, because it's just not our area of expertise. And so trying to create a perfect implementation metric for this new provision has been difficult, continues to be difficult. So we definitely appreciate everybody's comment. And of course, we'll come up with the best one that we can, and hope that it works. Thank you.
Thank you, Mr. Riley. And just to be clear, I didn't understand the AGs to have a problem with using tools like collection agencies and court actions if need be down the road once that payment period has expired, right? If we're gonna that they're okay with allowing kind of a payment plan, they just don't want to require somebody to sign a loan before walking off the lot. And it sounds like Mr. Forbes doesn't object to that either. So it sounds to me like we may have reached a balance that the different entities and stakeholders are comfortable with, I'm hoping. So we will discuss it in addition to some more if need be. Okay, does anyone else have any comments about the compulsory loans and their use or prohibition? Oh, Mr. Harden, you've got your camera on. Please go ahead and state your name and indicate who you're with, please.
Oh, Jacob Harden here. I'm the general manager of Elite Towing and Recovery. Not necessarily so much with the compulsory loan side of things, but with the document that's required from the state of Colorado. Is there anything else that we can get in addition to that for people to prove a way to be able to get a hold of them? We've had, for instance, we had one gentleman show up. He had a title from California with one address on it. He had a driver's license with a different address on it, also in California. And then the address he placed on the form was an address for an apartment complex here in Colorado with no unit number. So we don't have a way of tracking down who this person is, where he may legitimately be staying at. And then also maybe bring into account people that are abusing it and parking repeatedly at properties illegally and then coming in and taking out multiple loans with it. Is there anything in the provision that we can get to either prohibit from people from taking multiple loans out, or whatever they want to word it as, a payment plan until the first payment plan is paid up, and then a requirement to prove residency at a certain location, whether it be here or in another state?
Okay, let me put your question on hold for just one moment, Mr. Harden. I just want to make sure there's nobody else has a question or comment about the compulsory loan discussion. And I don't see any. Oh, no, Mr. Harden, please go ahead and leave your camera on. I don't see anybody, so I just want to make sure. So we're moving on to opening up the floor to any other comments and questions. So it's the perfect time to move into the topic you want to discuss. And there's really two different issues. So let's take them one at a time. Let's first talk about any additional documents that may be required in order to obtain contact information for the vehicle owner authorized operator. And I would caution you, my initial reaction to that is, if somebody is unwilling to provide you with their correct address and don't give you the full address, I don't know that there's much the PUC can do. I mean, we certainly can't force them to provide you more information. And if they don't have the wherewithal to give you the unit number, for example, I don't think we can regulate around that issue. I think the vehicle owner authorized operator is going to have the knowledge and wherewithal to know that the towing carrier is going to have that information if he's going to want to get his car back. But in terms of additional documents, can you tell me and give me a little bit more clarity as to what kind of a document you envision Because I'm not quite clear what you're thinking we should
Maybe
do.
even just a utility bill that shows, yes, this is a mailing address that we can contact this person at if we need to pursue any kind of further action against them. If they refuse to pay, because again, we've had multiple loans that are taken out and virtually nobody pays them back, as Trevor and some of them, no matter
Mhm.
what the stipulations for it would be. They just, once they find out that they may not need to pay, they come, they take their loan, and then that's the last that we ever hear from them again. So a way to be able to contact them legitimately,
Mhm.
and a way to be able to collect debt from that person at some point in time would be beneficial.
Yes, I understand the difficulty you're having. I'm not sure how much leeway we have, though, because the statute specifies what that individual needs to provide in order to retrieve their car. And if we start imposing additional requirements and barriers, we might be running afoul of the bill, the House bill. So I'm not. I understand the difficulty. I mean, does Mr. Riley have any response to that I'm not thinking about? Go ahead, Nate.
Thank you, Your Honor. So I don't really have too much feedback beyond what you've already stated. Again, with this new provision, what we've been calling the release without full payment provision, I mean, we really are given pretty clear direction by the statute that when a particular tow occurs, in this case, considering it's within the 405 statute, we're talking about specifically residential style tows. When those tows occur, even if it's the same vehicle over and over again, this is a provision that is available to those individuals when they're collecting the vehicle. So yeah, as the ALJ indicated, I don't know that there's any way we can regulate around that. I've known towing carriers over the years to try to collect every little piece of information they can from the people collecting the vehicles, just in case. So for example, if somebody came to collect the vehicle under the authorized operator provision, that requires them to provide a valid driver's license. So just that alone would give you access to the driver's license to, identify whatever identifying information may be contained on that identification. Or obviously we have on the, excuse me, on the form associated with this new provision, the release without full payment provision, we do have information for them to write in. So I would obviously suggest using all the information that you have available through these different metrics to give yourself the best chance to locate, identify, pursue collection of debt after the fact. But yeah, as the judge indicated, I don't know that there's any specific restriction we can apply the way you're describing without conflicting with the statute.
Does that answer that question, Mr. Hardin?
It does. Yeah. Thank you very much, Your Honor.
And you had a, excuse me, hang on. I apologize, something got caught in my throat. You had a question also about people having multiple loans and how we can address that. Do you want to speak a little bit more about that?
He actually had just addressed it, that there can be no restrictions put on it, whether it's one loan, 2, 3, or 4. The statute was pretty clear. So I think he had addressed that just fine. Thank you.
Okay. Thank you, Mr. Hardin. Was there anything else you had, any other comments or anything else you wanted to address?
No, thank you.
All right. Okay, as I indicated, I'm going to open the floor up to any final comments or questions regarding the proposed rules. We have run through the comments, the provisions that I wanted some additional discussion about because we had made further revisions and received additional comments about it. But the rules are lengthy and there are many topics to discuss. So this is the opportunity for anybody having any additional comments or questions to do so. Anything that you would like to address that we haven't already, please raise your hand and go ahead and do that. Go ahead, Mr. Forbes.
I just have a real quick question, maybe for Mr. Riley. Assuming some of the things we just discussed are adopted in the rules, for example, the 30 to 90 day provision, adding that to the PUC form, would that require a rule change, or is that something that staff could just incorporate on the form on their own without a rule change?
Mr. Riley, do you want to go ahead and answer that question?
I mean, I would defer to you, Your Honor, on whether or not you thought we could do that without a rule change. I think since it's not something that's currently contemplated in the statute, I mean, the statute does defer to the commission on the creation of the form. So maybe there is some latitude there. However, at present, that form mirrors the statutory language almost exactly. We did not take very many liberties at all in regards to that form. We were very stick to the language of the statute in that form. So I guess it would just depend on how comfortable we were in amending that form if we're currently in the process of contemplating, and I don't even know if this would be considered an expansion to the statutory language or not, considering that the form is essentially kicked to the commission to create and put together and put up on its website for towing carriers to use. I don't know. I'm leaning a little more towards we may want to wait to make such an amendment to the current form until we actually have a rule in place to support it. That's kind of how I'm initially leaning. However, I would have to speak to a few people to see if that's something we could do in a more active rule, something potentially changed before a rule went into effect. But I, for some reason, that's making me uncomfortable. And so I don't know if that's the appropriate way to handle it, but I hear what you're saying.
Mr. Forbes, do you want to go ahead?
Thank you. Yeah, I just want to clarify. I didn't mean prior to, basically saying if these were to change in the rules, for example, the 30 to 60 day 90 period, after that rule goes into effect, would it be within staff's jurisdiction, if you will, to update the form and say, you have, up to 90 days to pay and then can be turned to collections, just so consumers know when they read that form, what's going on after a rule's in place. And so I was curious if we had to change that in the rules simultaneously, or after the new rule went into effect, if staff could expand on the form and add those things if they deem that appropriate.
Mr. Riley, do you want to respond to that?
Of course, I would defer to the ALJ just to make sure we were doing everything in accordance with what you think is appropriate. But I mean, I would lean towards, if we have a rule that's now a permanent in effect rule that basically does make reference to a payment period schedule, I would imagine that would probably make its way into the form itself, having referenced that particular rule, which is now permanent and in effect. But again, that's just my perception.
Okay. Thank you so much, Mr. Riley. Mr. Forbes, does that answer your question? As it is, answers the question. I don't know if it's the full answer you're looking for, but hopefully that at least answered it.
It does. It does. Thank you, Your Honor. And thank you, Mr. Riley.
Thank you, Mr. Forbes. Okay. Anyone else have any questions, comments about any of the provisions of the proposed rules? All right. Does anyone else have anything they'd like to add or share with us today? Any anecdotes or statements they'd like to make before we conclude the public comment portion? And I just saw Mr. Bloom, did you want to make a comment? Your picture popped up, but I can't tell if that's your video or not. Mr. Matt Bloom. Mr. Bloom, did you want to say anything? Your picture popped up. I couldn't tell if that meant you're interested in making a comment or if you just joined us. No? Okay. Doesn't sound like it. Does anyone have anything else they want to add or state during this public comment portion? No? Okay. It appears that there are no additional comments. Nobody else interested in making or offering a public comment in regards to the proposed towing rules. So there being nobody else making such comments, it appears that we have come to the end of the public comment portion of the hearing. I want to thank you all for your comments regarding the proposed modifications to the rules governing the towing industry. Given the extensiveness and complexity of the proposed changes to the towing rules, I am continuing this rulemaking hearing again. I think and hope that the next one will be the last one, but given the discussion we had today, particularly in respect to the compulsory loan comments from the AG's office, I do think one more public comment hearing at least would be beneficial to ensure that the rules shape up in a form that as many people as possible are comfortable with. Extending this and continuing the hearing one more time will allow me and commission staff another opportunity to put proposed rules out there and solicit public comment about the revisions and changes to the proposed rules. It would also give an extra set of eyes out there to catch any typos or mistakes or alert us to anything that appears amiss so that we can make those corrections before these rules become final. The continuation of this rulemaking hearing will be on Thursday, August 31st, 2023, starting at 11:30 a.m. Further, in light of today's robust conversation about the proposed rule changes, I will also give interested individuals and entities an opportunity to provide additional written comments. Any additional written comments should be filed no later than Friday, August 11th. Given that we've already done multiple rounds of hearings and comments, I'm authorizing just the one round. We don't need to have reply comments. So just any additional written comments should be received by August 11th. I will be issuing a written decision memorializing the continuation of this hearing, as well as memorializing the opportunity for additional comments as soon as I can. But I would ask everyone to please note that the commission's calendar over the next several months is and continues to be extremely busy and full. So please pay special attention to the dates set in the written decision that goes out. I am hoping and believe that the next hearing can take place on August 31st. But if the commission's calendar gets full and there are conflicts arise between now and the issuance of my next decision, I may have to change that date. So I would ask everyone to please check the order to confirm that the next public comment hearing will be held on August 31st. That brings this public comment hearing in proceeding number 23R-0085TO to a close. Again, thank you all for participating. The hearing will be continued and we are adjourned until August 31st, 2023 at 11:30 a.m. unless a different time appears in my decision. Thank you very much all. I appreciate all your comments and appreciate your participation today. Thank you.